Hello, myself Muhammad Aman and my student ID is 201738. Today we are going to give a presentation on business law. Before we start talking about the above case, we need to understand that what is contract and what is agreement and what is the difference between both in the eye of law. Agreement. It is just a topic or concern on which both the parties are agreed. It could be oral or written, but every agreement cannot be contract until it, it is unenforceable by law. Contract. While contract is a written or oral agreement in which is enforced by a law, both the parties agreed on their concern and make contract so that their agreement can be safe and their plan can be executed smoothly. Case explanation. In the above case, as Dave is Karen's brother and he was ill and he asks her to take care of his, and in the promise that in reward he will give all his property to her after his death, and Karen was agreed on same, but after few months Dave disobeyed to his promise, and now Karen is looking to file a case against Dave in the term to breach the contract. But as we know that there was a oral agreement between the two in the above case, this is not mentioned that it was a contract. Hence, Karen cannot claim for property on the basis of an oral promise. As per the law, contract is that kind of agreement which is enforceable by law. But here situation are different. Here this is just a false promise of a brother to his sister. Hence Karen cannot file a case under the violation of contract law, as it was just an verbal agreement or a promise. So for this, if Karen has any kind of proof, then she may try to take help of police and judiciary on the basis of cheating or false promise and on the basis of misuse of trust. But there are low probability of getting justice on the basis. As for justice, judiciary wants proof and local advice, and also case should be as per the guidelines of law, so that as per law decision cannot be taken. So in conclusion, as we are talking about business law and contract, so already we discussed about the actual meaning of contract, so we can conclude that the above case was just a false promise of a verbal community or of a brother to his sister which is not fulfilled. So yeah, in all this scenario there is no provision to file a case on the basis of false commitment. Here in this second case, as we can see that the couple had signed a mortgage for a guarantee of their son debt, and also it is mentioned that they have a little understanding of English, and also it is mentioned in question that all their son led them to believe that his company finance condition is very good, but in fact there was serious financial issue in his company which he hid from them, and his parents believe on him, and they signed that mortgage without reading the memorandum. And when Ali's business went into liquidation, the bank tried to exercise their right under the mortgage, but all Ali's parents are shocked with all this. After understanding the issue, we can say that this case is related to misrepresentation by their son of them. In conclusion, after deep analysis of the above case, I want to express my view as per the contract law that here Ali's parents cannot get any relief from bank or from any other judiciary committee as because misrepresentation made by their son, not by the bank. So if they are unable to pay bank's debt, then bank have right to sell their home. In this case, there are 2 points which I want to present here: unconsciousness and misrepresentation. Unconsciousness: when the bankers come to Ali parents' house, then they don't ask them and they didn't inquire about what they are present them, where and what are the terms of conditions of it. And in misrepresentation, Ali hides the real financial condition of his company from his parents, but he shouldn't do this as we was in a huge debt, and he raised the fund for the from bank on his parents' home so that his company can run. In this case, Brad and Jane have a case against Angie for irresponsible misrepresentation. Dairy Peak established that one is accountable for making a false statement if they either knew or should have known that it was not true. One party misrepresent materials fact to the other party before the contract is formed to convince the other party to enter the contract. Anyone who enters into a legal binding agreement based on a fraudulent representation is entitled to who either void the agreement or get compensation for any loss increased. If Gulliver can prove that the bus tour business reached the contract, he may be entitled to recover his complete investment in the excursion. This concept of common law holds that if one party breach an agreement, the other misuse for mandatory damage, having failed to prove Gulliver with the promised bus excursion, the bus firms is in violation of contract. Shall we build a license board 149 CLR 620 is the application case. The court ruled that the plaintiff was entitled to full damage for the cost of the contract, notwithstanding the fact that they had only partially fulfilled their community. The court ruled in favor of the plaintiff, finding that the plaintiff was entitled to full payment under the contract since the plaintiff had fulfilled some of their terms and was precluded from fulfilling the remainder due to defending breach. So Gulliver must prove the following to have a legitimate claim: to have a legal binding agreement with the bus trip business, the bus tour company violation of contract, and Gulliver finance loss because of infraction. Other information: Gulliver has paid for the tip and the bus tour operator has acknowledged his cash. Thus, there is a legitimate contract between them. The fact that the bus tour firm did not provide the whole trip as promised is likely to prove a second element, a breach of contract. In conclusion, if Gulliver can prove that the bus tour operator breaches his contract, he may be entitled to recover his whole payment from the firm. This concept of common law holds that if one party breaches an agreement, the other may sue for monetary damage. In Shall We Build a License Board, the court ruled that the plaintiff was entitled to full damage for the cost of a contract even if the plaintiff one partially execute the responsibility under the contract. In this case, since neither party has contract, Russell Limited is under no obligation to sell Tom the plasma TV for $2,200 as required by Australian contract law. Advertising plasma TV to the general public is not an offer to enter into a but rather a request for interested parties to make offer in order to enter into a contractual negotiable, as there is no hard and fast rule on how may take the treat. Anything that is exhibited to a large group of people might be considered an invitation to treat. In this case, the main issue is, does East and Four Corner owe a duty of care towards Jean, and if so, is its breach or not? Rule: a duty of care can be described as a legal obligation for avoiding resulting harm, and occur where harm be considered to be responsible foreseeable the particular care is not taken. However, for the duty of care to be extinct, there should be sufficient relationship of proximity between the two parties. In reference to Australia's Safeway Stores Private Limited, an occupier holds a duty of care towards the intent of the premises for taking responsible steps for the person's safety and prevent his or her injury. In this case, as East and Four Corner owns the premises, a duty of care is owned by it towards all the visitors for providing a safe environment as per the Australian Safeway Stores Private Limited. Considering the factual consideration and scope of liability parameters, it can be seen that the injuries could have been prevented if proper cleaning and inspection process was taken by the store in the pet's action. In this case, Johnny owned a duty of care towards land. However, whether this duty of care has been breached or not is matter of consideration. This is because through a duty of care was imposed on a Johnny. However, the sudden hailstorm was natural climate and is not foreseeable of Johnny. But on the contrary, it can be argued that through the occurrence of the hailstorm was not foreseeable. However, the damage it could cause in the plant if cars was foreseeable. In this case, a main issue was whether Sam is liable towards a tort of negligence or defense can be relied upon by her rule. In reference to Amber v. McNeely, a learner driver holds the same standard object as held by any other driver. Moreover, as per this case, the defendant behaved carelessly beyond his mark price in drive the rejection the plaintiff arguments who have assumed the occurrence of risk of having an injury due to this the overturning of the vehicle occurred. Hence, in this case, there has been a breach of duty of care, no matter how inexperienced the defendant was, or there had been a process of contribution negligence, because the occurrence of the issue was due to the careless attitude of the defendant and he owned the same degree of standard of care as was owned by another experienced driver.